To introduce myself, my name is Angelica Dill. I'm one of the co-founders alongside with Trey Gordon. He's the other co-founder of Adjacent Space. By day, I'm an American Sign Language interpreter and a stay-at-home mom. But also by night, I'm, trying to figure out how to run this thing, alongside of Trey and a lot of the other team members that are volunteering to make all of this happen. Our mission is to promote accessibility and equity for the deaf, hard of hearing, and deaf-blind community. Elevating accessibility and equity takes on different forms, but we mainly seek proactive action as well as responsive action to discrimination, which is, part of what we're talking about tonight. And I want to point out that Ed here, elephant in the room, is in fact a lawyer. He does sue people for a living. People a lot of times don't like lawyers, but I do want to point out the fact that he gives his time to us. He's volunteered a lot of hours to respond to our questions. Give you a little bit of background. When we first started as a tiny little organization, we were super new and we reached out to a lot of lawyers in the area, and Ed was the only one who responded. So I think that speaks volumes. He's done a fantastic job at advocating with us and seeking out proactive action. And again, that's one of the ways we want to approach some of the discrimination and accessibility that happens in our community. Again, Ed's here. Thank you so much for your time. Can you tell us a little bit about yourself?
Yeah, absolutely. My name's Ed Zwilling. I moved here to Birmingham in 1989 to go to law school. I graduated in 92, so I've been practicing for 29 years. And starting in about 2002, I guess that's 19 years ago now, I started primarily representing people with disabilities. I had represented people with disabilities before that time, but it really became my primary practice area in 2002. I left the firm I was with at that time in 2018 and opened my own office. And that is still my primary practice area. I represent folks with disabilities under the Americans with Disabilities Act, the Rehabilitation Act, the Fair Housing Act, and there are a host of other laws that apply in unique situations. The Air Carrier Access Act, the Help America Vote Act, the Individuals with Disabilities Education Act, and there are many federal laws that protect people with disabilities. And so my mission here, and generally when I speak, I do a lot of self-advocacy workshops, is to empower people with disabilities, because knowledge is power. And if you know what your rights are and how to enforce them, hopefully you can be a much more successful participant in our society. So that's why I'm here.
That's great. So it's not just the ADA. There are a plethora of laws that you're tapping into and trying to figure out how that applies to the people that you work with. Yeah,
exactly.
Awesome. Okay, we're going to start off by taking a couple polls to see kind of who's out there right now. And also I want to point out, I do see the questions that have already been asked out there, and we'll get to them at some point, just kind of as we can stick them in. We do have a couple questions that we kind of just had pre-existing, and so we're going to kind of do a little bit of both throughout this time. Also, if you are a deaf person who uses ASL as your first language and you prefer to ask the question in ASL, we can spotlight you and put you on video. And then again, you can just put them in English in the Q&A chat area. So let's start with our first poll. Can you see the first question? Yes. Go ahead and take the poll if you are able to see it. Oh, so it's all 6. Again, we're very new. We were going to give them to you at different times, but we'll just go ahead and see who's out there, take the poll, give them to you all at once. Somewhat familiar with the American Disabilities Act. Okay, it seems like that's a common answer. I'll wait and give everybody a moment to look through these. Can everyone view all four screens? Looks like someone can only view me. Yeah, it's probably a gallery view that you need. I like that the audience is troubleshooting as well. It's great. All right, let's just go ahead and go through some of these responses that everybody said. So how familiar are you with the Americans with Disabilities Act? A few said very familiar, and most people said somewhat familiar. I think that's pretty true for the people that are in our audience right now. Being familiar with the ADA, sorry, Diane, I'm just zooming through this. Being familiar with the ADA, the individual's responsibility, we had one person say that. And then everybody else says everyone's responsibility. We all need to be familiar with and work towards the goal of equity. And the third one, looks like we have a mix, deaf, hard of hearing, deaf blind from the deaf community, a family or friend of, or a business owner, employee of a business. And then in a recent poll, people with disabilities have said the toughest hurdle with the ADA is finding compliance, finding employment, or understanding the law. And actually the answer to that one, it looks like we kind of had a mix there, is the answer that most people said was finding employment, which is very interesting. And then how often do you personally see, work with, or interact with people with disabilities? Most of you said often. That's really awesome. And then we're going to circle back to this at the end because we kind of want to know what you guys are interested in the future, but what you're most curious about. Most of you said other. I'd be curious to know what else, but maybe we'll circle back to this at the end and ask you what else you're curious about after Ed kind of goes through some things. But some people said how to provide appropriate and reasonable accommodations, and then how to make successful accommodation requests. There's one person that said that, but most of you said other. So we'll ask that later on. Very cool. All right, let's dive into our first question, and then we'll kind of circle back to some of the questions that have been asked in the audience. So in our community, businesses and nonprofits often respond to providing interpreters. The response is usually, we don't have the budget for that. That's a very common response that we hear, especially as an organization. Also, myself as an interpreter, it's just something that we commonly hear. A majority of our community, although we do have a mix of hard of hearing individuals, you know, there's different methods of communication. They might rely on oral English or use hearing aids, cochlear implants, etc. But most of the time, they're only going to be effectively using American Sign Language to get their services or, you know, be a customer or patient. English might be a second language to them, therefore trying to accommodate with a written transcript, writing notes back and forth, or other visual tools are usually not as effective. And according to the ADA, a business or a nonprofit has to prove undue burden to not provide a reasonable accommodation. We know that an entity is legally obligated to look at their whole operating budget rather than a specific program, because we often hear, well, that class, if, you know, we paid for an interpreter, that would be more than we would incur for that class of, you know, the fee or whatever it might be of that program. So they respond that way, thinking that that specific program can't cover the accommodation. Other times they respond this way because they see the interpreter costs money, or they don't realize that they're legally obligated to do this. So Ed, from your perspective and all of the knowledge that you know, what can an individual do, or what's the next step in the response to this business if they get that response?
Well, a lot of times businesses will give that knee-jerk response, and it's a response out of ignorance. It's not based on any actual understanding of the law or what responsibility the business has. For example, with regard to architectural barriers, for like a wheelchair user, it's very common for me to hear, oh, we're grandfathered in. There's no grandfather clause in the ADA. Doesn't matter how old the building is, there's no grandfather clause. So when we're dealing with effective communications, there's a great document, a guidance handout, I guess you would call it, from the Department of Justice on effective communications. I think I had put it in the chat box. I'm not sure if everyone who's a participant can see that link, but if somebody could post that, that would be good. I would encourage you guys to read that and get very familiar with it, because it's a really great summary of what your rights are. It doesn't necessarily tell you how to enforce them, and I'll go through that in just a sec. But you know, it's possible that a business doesn't have the resources to provide an interpreter for the deaf. But I would think that those circumstances would be few and far between. Generally, when you're going to ask for an interpreter, in my experience, when people really need one and they're not and haven't gotten it, it's been in the medical setting and they're in a hospital or something like that. In that situation, I don't think that excuse would ever hold water. Because what you look at is the overall size of the facility, the number of its locations, the number of its employees, whether it has a parent company. And if so, the same analysis goes toward the parent company. How many locations, how many employees? And so if you're dealing with a very large corporation, and most businesses that operate hospitals don't just operate one hospital, they operate many hospitals. They're very, very large. And it's just a cost of them doing business. And so for them to say, we're not going to do that, and to tell the person with a hearing impairment that you have to provide that for yourself, is a direct violation of the ADA, where it's clear that they can afford it. So what do you do when that happens? So I look at it as 3 levels of self-advocacy. Level 1, the most basic level, I'm going to call it letter writing. And let me explain what I mean by letter writing. So since I started with the medical example, let's just stay there. So say that you show up at the emergency room. You know, you've been in a minor accident, but you need medical treatment, and it's emergent. And so you show up there, and you tell the receptionist there at the desk, who may or may not be a nurse, that you know, you're deaf and you need an interpreter, and you know, you're bleeding, or whatever the case may be. It may not be obvious what your symptoms are, but that you need an interpreter. So you know, they may hand you a clipboard and a pencil and a lot of paperwork to fill out, and they may not, for all you know, they're calling an interpreter. They may not be calling an interpreter. You just don't know. Well, if you never get the interpreter, your rights have likely been violated. In an emergent situation, that's very often when a hospital is going to roll out VRI, video remote interpreting. But there are still, especially if you live in a rural part of Alabama, there are hospitals that don't have VRI. So, and they don't have a lot of interpreters in rural Alabama either. So, you know, if you're in the greater Birmingham metro area, you're in Mobile, you're in Huntsville, they don't really have an excuse. But if you're out in the middle of nowhere, Alabama, I won't name any names, you know, there may not be a whole plethora of interpreters for them to have. But bottom line is, they have to make some effort to effectively communicate with you. And if you don't feel that that's happened, there wasn't an effort to determine whether, you know, passing notes would help you, whether speaking loudly or demonstratively would help you, whether sharing a computer screen would help you, in the case where they don't have an interpreter, or whether VRI would help you, or any of these other things. Well, and they just ignore it. Well, then there's not even been an interactive process, and that's just as dismissive as can be. That's offensive. In that situation, when you write your letter, you're not going to address it, obviously, to the person you dealt with behind the counter. That's someone who's very low on the totem pole. I always tell my participants in my workshops that when you're dealing with a business, you need to be business-like. So what you should do is address your letter to the owner or the operator of the facility. How do you find that out? Well, there's lots of ways you can do it. Generally the hospital has its owner in great big letters on the building. I'll give you an example. This is not to pick on anybody, but like St. Vincent's is no longer St. Vincent's here in Birmingham. It's now Ascension St. Vincent's. St. Vincent's was purchased by Ascension. So that's who you would write, is you would write Ascension. You would probably, I would advise you to enclose the guidance that I referenced from the DOJ that sets out what the rights and responsibilities are of people with hearing impairments and of businesses who are serving them. And then you're going to let them know why it is you need an interpreter. Maybe English is a second language for you. ASL is your primary means of communication. A lot of people don't understand that. Mm-hmm. That they expect everybody speaks English and sign language is just a way of communicating in English, which is not at all true. So you're going to have to educate them. And then you're going to have to tell them what you expect and what you want. And then when you don't hear back from them, you have to follow up. But you have to be persistent. So the letter writing campaign is the first method. The next, you can step that up. If you don't get a response, the next thing you can do is file an administrative complaint. Now, where you file the administrative complaint varies based upon the type of facility. So in this case, we're dealing with a hospital. You could file it with the Department of Justice. You could probably also file it with the Department of Health and Human Services. I believe they have an Office of Civil Rights. If this were happening at your university and you weren't being accommodated in class, or when you went to visit with a professor during office hours, or whatever the situation may be while you're in college, you would file it with the Office of Civil Rights with the Department of Education. But if you're not sure exactly where to file it, you can't go wrong filing with DOJ. If there's a more appropriate agency, DOJ will refer your complaint there. And then you hopefully will have someone in the federal government who routinely works with people with disabilities looking at this claim. And if they feel it's one that's worthy of litigation, they may turn it over to a United States attorney. I have had people come to me who had already filed DOJ complaints. And in the midst of my representation, out of the blue one day, I've gotten a call from a United States attorney. So I do know that happens. Mm-hmm. But by and large, the DOJ, the Department of Justice, is a large administration that oversees the whole country. And so you can't expect that you're going to get individualized attention to every claim that you file by a United States attorney. You're probably not. But if they're looking for the type of case that you happen to turn in, or if you're one of 30 people who turned in a complaint against the same facility, they will recognize that. And those are the ones that they take more seriously.
I want to interrupt just for a second.
Yeah.
Right back to you came in, whether it's an emergent situation or what have you, you requested for an interpreter. The emergency is happening right then. Your medical need is happening right then. So yes to letter writing, yes to all these things that I think can be very effective. But in the meantime, what do you do in that moment? Because the time is passing when you need the interpreter and the damages are happening in real time. So, I mean, what is it that you can do to kind of nail someone in that moment? We're saying receptionist probably doesn't know. Is there someone else that you should try and be asking for, something you should do?
You can certainly take it up the flagpole, obviously tell the nurse, tell the doctor, but all of those people in a hospital setting are employees. None of them have policy-making power to create an effective communication policy for their hospital on the spot. So if you're there and you're not being accommodated, they probably don't have an effective policy. And if they do have an effective policy, they probably don't have effective training in that policy. And those employees don't know what they're supposed to do.
Which I would point out, sorry again to interrupt, but this is what you do. I mean, again, I want to just highlight the negative so I can show the positive.
Right.
Suits, the result is, unfortunately, the company is sued, but then policies are created and people are trained, and then we can progress from there. But without the policy within the system, a lot of times then, people don't know what they're doing as an employee.
That's exactly right. And so that's why there's not a magic wand that I can give you that will be sort of your trump card to ensure that you're accommodated on an as needed basis as you go through life. Unfortunately, there's nothing like that out there, because at the end of the day, it's a civil matter. It's not a criminal matter. It's not like you can call the ADA police and they'll arrest them if they don't provide an interpreter. That's not the way that it works. So the letter writing campaign is what you can try and do to affect change proactively after the fact, so that if you return, that doesn't happen again, and so that you can leave a legacy of access to other people who are similarly situated who may come after you. If the letter writing campaign doesn't work, there's the administrative complaint. But the third option is sort of your nuclear option, and that's when you hire a lawyer and file a private suit. The ADA has a right of private action. The Rehabilitation Act has a right of private action. So does the Affordable Health Care Act. And all three of those laws require an interpreter for the deaf in a hospital setting. It has to be determined on a case-by-case basis, but they're supposed to have policies in place to make that determination as needed. Now, if you forget everything else I've said about this third option, remember this. All of these federal laws I've mentioned have a prevailing party attorney fee provision. So you should not have to come out of pocket to enforce your civil rights. So if you talk to an attorney and they want to charge you a fee, a retainer fee, an hourly rate, or whatever, to file the lawsuit for you, that should tell you one of two things. Either that lawyer doesn't know what he or she is doing, or your case isn't as good as you think it is. And what effective communication policy should exist, again, it's determined on a case-by-case basis, and you have to look at the actual plaintiff in the case, the person with the hearing impairment, but you also have to look at the facility. And so, every now and then I'll see a case that I don't think is a very strong case. And in those situations, I'm more apt to quote a fee. But if I believe that you have a strong case, I'm not going to charge you anything to bring suit. And then if we don't recover anything, you don't owe me anything. And that's the way that you should be handling your case. And what I always tell my clients is, if I'm not willing to invest my time and expense in your case, you shouldn't be investing your time and expense in the case either, because this is what I do for a living. And if I don't think it's good, please, you might want to take me at my word. And if you don't, I can certainly get you other folks to get second opinions from. But what happens when you file a lawsuit? At that point, you're no longer drafting letters. You're not filing the complaint. Your lawyer's drafting it, and your lawyer is dealing with their lawyer. And the types of things that we're asking for are a policy to be created that complies with the ADA, that their employees be trained in that policy, that policy be posted on their website, and in some cases we can get damages. It really depends on the situation. But there are certain cases where you can get damages. If the Rehabilitation Act applies, you can get damages if the discrimination is intentional. If the discrimination falls under the ADA, but it involves a core constitutional right, say you're denied an interpreter in court when you're on trial for some crime, that would be a core constitutional right. You could potentially get damages for that. But I hope that answers the question.
Yeah, I think we could go on about this question in particular. I'm always curious about the undue burden, and I think it just sounds like it's a gray area. I guess what I am disappointed in with the ADA is that there's no percentage, or there's no specific number like a lot of the other 8 parts of the ADA, such as building codes and measurements. It doesn't address it the same way for the deaf community, and I think that's where
let's talk about that, because there was a push in the 2010 amendment, and you raise a good point. Because the biggest gray area is, quote, readily achievable. And that applies to removing architectural barriers in existing construction. So say you got a building that was built in the 1950s and it has broom closet size bathrooms that you can't fit a wheelchair in. So is it readily achievable for them to blow out walls and widen doors and make the room bigger? And the question is, it depends. And so and it's the same type of analysis as for undue burden. How big are they? How many locations? How many employees? You know, you look at what's their income, what's their operating expense. And there was a push to say, well, maybe if they spend 0.5% of their gross revenue, that would be fair on an annual basis. Maybe it should be 1%. Maybe it should be 0.25%. Maybe it should be on the net. Nobody could agree on what was the appropriate amount of money. So we don't have it. And the problem is if you give a percentage, then there are going to be people who are just going to be exempt. I mean, they don't have to comply at all. If you keep it gray, then they have to make a cost benefit analysis. Am I going to go without a net and I'm not going to accommodate people and risk getting sued? Or maybe I should provide accommodations, even though I think it's too expensive and I really can't afford it. Maybe I should do it just to avoid getting sued because that'll be more expensive.
Yeah.
And so sometimes the gray area can be beneficial. So, okay, I hope that
Yeah, it does.
shed some light on that situation. But I understand what you're saying, that there's not certainty, but that's a two-way street, and you can use that to your advantage sometimes.
Yeah, definitely. Okay, we're going to ask our first question from the audience, from Beth. She says, I work for Alabama Department of Rehabilitation Services and often work with employers when it comes to job development for deaf and hard of hearing consumers that she works with. My question is, how can I educate the employers about ADA that she's bringing these consumers that she's working with,
Right.
providing accessibility to their deaf employees?
No, that's a great question, and that's a tough one. You know, especially when you're dealing with smaller employers who may not have, a human resource director, may not have legal counsel. This is just all folklore to them. They don't really know what they're supposed to do. But the bottom line is, what accommodations are due really comes down to, you have to look at it. It's a much more narrow analysis when it's employment based. You have to look at what are the essential functions of the job and whether or not some accommodation is necessary for the employee to perform the essential job functions. And to the extent that there is, then they have an obligation to provide accommodation as necessary to enable the employee to provide the essential job function.
And this has to do with the EEOC and the ADA sort of coming together, right?
Well, yeah, see, Title I of the ADA has an administrative remedy that none of the other titles of the ADA have. So employment is Title I of the ADA, and you have to exhaust your administrative remedy and go through the EEOC before you could file a complaint. Whereas before, if you had gone to the emergency room in that example, you could go right to the Department of Health and Human Services and file a complaint. You could go right to the DOJ and file a complaint. You could go right to court and file a lawsuit. But if you worked at the hospital, you couldn't do any of that. You'd have to go to the EEOC and exhaust that remedy before you got a letter, which is, colloquially known as a right to sue letter. But yeah, it's tied to the essential functions of the job. So that means if there are communication accommodations that the employee would like, it would make him feel more, or her feel more comfortable, feel better, feel more a part of the team, but they're not truly necessary to perform the essential functions of the job, then there's not an entitlement to those.
I think, though, with deaf and hard of hearing specifically, whether you use ASL or not, communication is everything. I mean, it's a part of, incidental learning, whether you learn from another coworker what they do and how they do it to make your job better, or talking to your boss randomly, or going to a meeting or a training. I mean, it's so much incorporated in every day of the job that it's essential for all of those pieces to come together. And I think, as we saw in the survey and the response that I was giving everyone, that the biggest barrier has been to get employment, and probably to keep it, or to probably be successful in their employment. That's huge.
Sure.
Yeah.
Absolutely, no doubt, no doubt. Employment, transportation, housing, healthcare, those are the big four.
Yep. Awesome.
Um,
Let's
But
move.
yeah. The key though to take away is that there has to be an interactive process. If a request for accommodation is made and it's just summarily denied, that in and of itself is a violation of the ADA. There has to be a back and forth and a dialogue as to why the request was made and whether or not some other accommodation might also work. And so the employer is free to suggest other ones, but there has to be a give and take and a back and forth. There can't just be a summary rejection and no further conversation.
And probably that needs to be on record too from the employer. They need to show proof that they had that conversation with the employee and said why they said no about this specific accommodation. And if not, then they don't have that paper trail. And
That's right. And the employee should always make those requests in writing as well, so that they can prove that the request was made. And always ask, if you get an oral response, always ask for it in writing. And if you don't get it, I always advocate sending a confirmatory email or letter after the fact, confirming what you heard, and giving them the opportunity to correct it if what you're stating is wrong. And in that, so you can always create the paper trail yourself. You don't need them to do it for you, but that's how you do it, is you send them an email confirming what they told you.
yeah. Okay. Awesome. I'm going to tie in a question that we had asked previously with you, but also with a question that we had from the audience. First, I'll ask the question we had prior, and then I'll follow it up. How can companies and businesses reasonably prepare for ADA accessibility obligations, such as preparing a budget or their policies, that sort of thing, and necessary communications for whether it be a client, patient, consumer? And then the question from the audience was for new business owners who is deaf, a deaf or a disabled owner. Do you have any good advice for them? So we kind of have a opposite kind of situation, which is interesting. So I don't know if you want to address both of them at the same time, or take one at a time.
Right. No, I saw that question, and I'm looking at my notes for the one that you had asked previously.
Yeah, it's the second one.
Oh, I see. Forgive me. All right. Well, as I said before, there's no ADA police. So that's the problem, is that the ADA is only enforced by people with disabilities. So if you don't know what your rights are and don't try and enforce them yourself, there's no one else who will do it for you. And so if you're not being accommodated, it's because you and everyone else who is in that situation have not advocated enough for effective communication. I mean, it's as simple as that. I think there was a study that was done, it's probably been 15 years ago, that something like 0.5% of the people with disabilities are doing all of the advocacy work on behalf of everyone with disabilities. There's not a lot of people out there that file lawsuits to enforce their rights.
It's so much pressure though on individuals, which, I mean, that's the hardest part. I think that's the biggest barrier.
Right. And so, even if you're not the type of person that wants to be the plaintiff on the complaint, I would still encourage filing administrative complaints, because again, that creates a paper trail and lets the government know that you had this problem on this particular time. And even if they do nothing about it when you file the complaint, when someone else files a complaint, now they've got 2 complaints about the same place. They get a third or a fourth, I think they're much more likely to do something about it. It's kind of like, it's a sad commentary, but I live off of Highway 280. And you can tell where people have died based upon where the traffic lights are on 280. As you get further into Chelsea, you pass Greystone, pretty much every one of those lights between Greystone and Chelsea, that was put up because somebody was killed
Wow.
at that intersection. So, you know, and unfortunately, that's the way ADA law is it's reactive.
Yeah.
It's reactive to the complaint. There's not any penalty for people who go about violating the law until someone holds them to account. And the only people with legal standing to do that are the people who are affected by it personally, people with disabilities. So, you know, I don't know how else to say it.
Yeah. Yeah.
Now, I don't know what to tell a deaf business person, a deaf entrepreneur who's going into business, because the question as I saw it was just, do I have any general advice for them? And I'm not really, I don't have any general advice. I don't know that it would be any different than anyone going, you know, opening up their own business. And yeah, I have tons of advice, but I don't know that I have much advice that goes along with this particular topic. For a deaf business owner. There was another question that I wanted to reach out real quickly about.
From Tiara, I think I'm saying.
Yeah, the one about the IEP. She wants to know when the IEP takes effect, and the answer is I don't know. I think after you've had the IEP meeting and it's signed, it's in effect. So if you've had the IEP meeting, the IEP was written up, and everyone has signed it, I think it's good. And if your son transfers to a new school, that IEP should still be in force and effect. And if they don't want to recognize it because it wasn't their IEP, I think that's just tough. The flip side of the coin is if it's not good, if it hasn't been fully executed, and there's some legitimate question as to whether or not it's binding, you should request another IEP meeting as soon as possible. And I recommend that you contact ADAP, the Alabama Disabilities Advocacy Program at University of Alabama in Tuscaloosa, and ask them for the name of an advocate to attend the IEP meeting with you. You'll be much more likely to get what you need if you bring the guns to the meeting. And trying to bring an IDEA case on the basis of there not being what you need in the IEP is much, much more difficult than bringing an IDEA case to enforce an IEP that has what you need that they didn't comply with. So I hope that's helpful. Yeah.
Somebody was asking about the other document. I think that they're referring to potentially the ada.gov effective communication document you're referring to. I'm not sure that that was put out there. So I'm going to have Anna from the chat find that as well, because that's what you're referring to.
That's right. I might can just put it in the chat again. I think it's the last thing I pasted. Let's see if it's still there. Yeah, there it is. I just added it.
Okay. And somebody asked, I'm going to ask one more question from the audience, then I'm going to jump back to our notes. Someone said that, are there advocates who can speak on behalf of someone who can't afford an attorney? I'm assuming they're just saying, can somebody be alongside them? You know, who else could that be? Like you said, you don't charge people when you see that there definitely is a case.
That's right. That's right. I do not charge folks when I believe they have a good case. The only time that the only exception to that is when there are some facts that make me think the case isn't as strong as I would like it to be, such that I'm not willing to take the risk. And I always advise my folks, yeah, if you want to pay me, I'll do it. But my advice is to not, because if I'm not willing to risk my money, you shouldn't risk your money. But if you have a good case, it shouldn't cost you a dime to find a lawyer to advocate for you.
Yeah. And I think that as far as an advocate goes, I think that that could be a lot of different roles. Interpreters sometimes kind of take on the role as an advocate in certain moments, but a lot of times we need to kind of stay within our professional boundaries. So that is something that sometimes can't be utilized. In schools, that looks a little bit different. Adjacent Space does try to be that person or that organization to be alongside of people as, you know, a support system, or, you know, it looks a lot of different ways. But I would be curious as well as, you know, to see if there could ever be something developed into somebody that's an advocate and kind of alongside that person, maybe helping take notes and memos and that sort of thing. Because I think that the paper trail that you're referring to, I think is very cumbersome. And I think that that's the hardest part, is that there's so much pressure on the individual. There's so much pressure on that family member or person that is trying to make sure that their own rights are being accommodated, while they're experiencing something. They just had their father pass away and they need an interpreter, or they're going to the hospital for some reason and the emergency situation is happening right now. And so I think that that's a lot for somebody to take on. So yeah, I'm not sure I personally have that answer either. I don't know if you have anything else to add to that.
I don't. The other resource, and it's the same place that I referenced for the IEP, but the reason I reference it for the IEP is that back in the early 2000s, the IDEA was somewhat gutted, and it made it much harder for the parents of a child with a disability to find an attorney to take a case like that, because it's much harder to actually get the attorney's fees awarded in that situation. And so as a result of that, because ADAP is the federally mandated and federally funded protection and advocacy organization here in Alabama, they have taken the IEPs on as something under their mandate that they will help the parents of kids with disabilities with. And they do take those cases on occasion, and they work with lawyers who handle those cases as well. So it's the best place for you to start. But they handle pretty much the whole host of ADA type situations. And so, in a case where you can't find an attorney who's willing to take it, I always recommend checking with ADAP, because, like I said, they're paid by the federal government to advocate for folks with disabilities here in Alabama.
And did you say that you provide free consultations? How do you handle that when you're first approaching?
I do. I don't charge for the initial consultation. Many times that's just shooting emails back and forth, sharing some documents. Sometimes it's a phone conversation. Sometimes we meet in my office. When we meet in the office, I usually try and limit the free consultation to 30 minutes. But I can generally tell if it's a case before that, if we can either talk or email in advance.
Yeah. I'm going to jump down to the question about currently kind of what's happening with the pandemic still going on. Everything kind of still feels virtual to me anyway. I think a lot of our lives kind of went a little bit back to normal, and then we, kind of shifted again. So last year when we hosted our first Q&A with you, we asked this question kind of similarly. I think it was just about 6 months into the pandemic. I, at the time, had asked you what you saw in any shifts virtually. We started using Zoom more often. There's a lot of webinars, conferences were going online, social media content even. I mean, there's just so much being pushed online. And at the time, we asked about how our rights could be met. And I'm wondering now, as far as the ADA goes, I don't know if any suits have been made since then, if anything has changed with the ADA, and how things have been shaped by the pandemic, because at this point, we're probably about a year and a half out. So has anything been shaped because of it? Are any rights being met? Because before it just felt like there was tons of barriers everywhere because everything was online.
Well, I'm involved with a case that may shape policy some. We'll see. I haven't filed it yet. I'm working on it. But because so many things went remote, one of the things that went remote for a lot of places, and only went remote in this place briefly, and then went back to normal, are city council meetings. And so, it used to be generally, if you wanted to speak at a city council meeting, you had to attend the meeting. And then at the end of the meeting, there was some time allotted for public comments, and you had the opportunity to address the council and have your thoughts be known on whatever the issues of the day were. Well, during the pandemic, they started having these meetings remote and allowing the public to attend the remote meetings. And so there are people with disabilities who were not able to attend the meeting not because the meeting itself was inaccessible, but because they were basically bedridden for a time. Say you have relapsing and remitting MS, and you're having a bad day, and it just happens to be the Tuesday night of the city council meeting, and you really wanted to speak on something, but you're stuck in bed and there's no way you're going to make it there. Well, you're being excluded on the basis of your disability. And the pandemic has made that clear, that these meetings can be held virtually, that comments can be phoned in, can be given via Zoom or other media. That we have technology to where you don't necessarily have to be there in person. And so I think it gives rise to both an ADA claim and a First Amendment free speech claim. If the city council wants to hear people speak, then that's great, but they can't exclude people on the basis of disability. And if your disability prevents you from attending the meeting in person, then that's what they're doing. So anyway, I know that's been on my radar. But yeah, all of these Zoom meetings, I think would also give rise to work accommodations like the first Q&A question we had, about how the lady from Voc Rehab wanting to know, how do I let employers know what they've got to do? Well, if you're going to have a Zoom conference and require your employees to attend it, then you may need to provide an ASL interpreter. You may need to provide captioning. It just depends on what the communication needs of the hearing impaired employee are. So, yeah.
That kind of leads a thought to my next question, but also Trey and I went to the National ADA Symposium about a month ago. I think I briefly mentioned that we were going to attend that, and a lot of questions came up, but it's complicated to think about how, again, back to the undue burden kind of situation where somebody's responding and say, no, I can't afford that. How can we prepare these businesses to be able to address these moment by moment situations where, Beth in our audience was asking, how do I tell them you have this deaf employee now? You need to address them. Obviously, there's going to be some things that are just attitudinal shifts. How do we do these things a little bit differently? Sometimes it is financial because interpreters cost money, captionists cost money, that sort of thing. But how are businesses able to identify that? How are they able to build that budget, create a plan around that when maybe they have never had to do that before because they're a company, they've never hired a deaf person or something like that. But also within our training, kind of leading into this question that I had asked you before, we had learned that 50 or more employees at a business meant that technically by law, they're supposed to have an ADA coordinator, whether or not they name that or not. They have to have a designated person that is in charge of being familiar with the law, addressing how they're going to approach certain policies, how they're going to design the workplace to address some of those barriers. But how are businesses able to set up for that? I mean, a lot of times it seems like they're unaware of their legal responsibilities. A lot of times they've never had to have that experience before. So all of a sudden they have this huge line item on their budget that they didn't have before. So just thinking as an organization, Adjacent Space is trying to educate a lot of people. Like we said, we have proactive action that we're trying to constantly address. Sometimes it's reactive because, that's just kind of the nature of our society right now. What kind of comments and thoughts do you have on that?
Well, I've got to tell you that I was not aware that 50 or more employee guidance applied to a business. I'm familiar with it in the Title II arena, that is governments like cities, counties, municipalities, what have you. If they have 50 or more employees, and they're required not only to have an ADA coordinator, but they're required to do a self-evaluation. They're required to do a transition plan. Title II of the ADA is a lot like Section 504. If any of you out there, had a disability as a child when you were in school, you probably had something called a quote 504 plan, which is what we had before we had the IDEA. It's basically the IEP, but it used to be called a 504 plan. And basically all cities, counties had to have a 504 plan with regard to any program, service, or activity that benefited from federal funding. So, if you got Department of Transportation money, well, then you had to look at your sidewalks and make sure that you had curb cuts in them for wheelchairs and things like that. And so I haven't done the research to see where that language applies to a business, but I'll just answer the question from the assumption that is indeed true. I don't have any reason to doubt you. But I'm not aware of any business, and I have sued some of the biggest businesses, and I have never been contacted by anyone claiming to be the ADA coordinator of a business. I have been,
just so you know.
yeah,
Yeah.
I have been contacted by ADA coordinators from some municipalities, but even some very large municipalities don't even have them, and they're supposed to. And very often when they do, that person is wearing a couple of other hats. He might be the facilities guy for the parks department, and they just make him the ADA coordinator too. So to answer your question is I don't know, how they prepare for that. But this whole idea of doing a self-evaluation and a transition plan, that's basically, in a nutshell, what any lawsuit that I've ever handled under the ADA really turns into. Is we're looking at their business from the standpoint of my client. And in most cases, now sometimes it's been someone who's deaf and needs effective communications. I have handled many of those cases, but the vast majority of them are wheelchair users. We're looking at, they got to be able to park, they got to be able to get in, they got to have maneuvering clearance at doors, things have to be within reach, bathrooms have to be accessible, and we go through everything. Well, like I had a case against the Birmingham Jefferson Community Center back in 2004, and we had deaf and blind plaintiffs as well as wheelchair using plaintiffs. And so we looked at providing open captioning at the arena during basketball games, because at the time I was representing the basketball coach for the Talladega School for the Deaf. And when he had played in the tournament there, he had no clue what calls were being made by the refs. If he didn't happen to be looking right at him when they made the call, he didn't know what the call was, because there was no effective communication. They were not captioning what was being said over the loudspeaker. So open captioning is what we got to solve that. We had visual alarms put in the fire system in the rooms that didn't have visual alarms. Otherwise, a deaf person would not know that the fire alarm is going. So these are the types of things that you only realize are required when you look for them to see if they're being provided.
Yeah.
And so if you're not looking for those issues, then they're only going to know about it if the person with a disability is being a squeaky wheel and making it known that they're not complying.
And that's why today we need to make sure we have better diversity boards and, my more diverse employees and just diversity across the board, because that's when we learn from other people. And then we learn, oh, that's accessible to me, but not to you, or that's offensive to you, but not to me. And, these things won't come up until we open up, and like adjacent space, we often say, create space. We need to create space for those moments. And I think a lot of times until we allow people to talk about that, about their own experiences, you're right, until we look for ourselves, or until we're being sued, or until all these other things come up, we don't know about them.
It's always cheaper for the business to do that self-evaluation on their own. And when the ADA was first passed, all of the people who do expert work for litigation now, they were all formed doing voluntary compliance work for those concerned businesses that wanted to comply with the new law. But very, very quickly that work died out. The experts that I know that have been doing this since the early 90s, when the ADA was first passed, said that they only probably had 2 or 3 years of voluntary compliance work. And then it all turned into litigation.
Yeah.
Generally, folks aren't going to do what the law requires until they're made aware that the law requires it.
Yeah. Education is everything. Well, to not take up more of your time, it looks like it's about that hour mark. I want to thank you, Ed, so much for your time. Just know, everybody in the audience, if you don't have a chance to ask a question or if something popped up later, you can always email us at info@adjacentspace.org. We're always happy to provide resources or direct you towards Ed, or if Ed wants to share his email. I know that he said he's happy to have a free
I'm
consultation.
going to put it in the chat. If you have a legal question for me,
Yeah.
You can email it to me. Where'd it go? There it is. All right.
We did put a survey in the chat as well. If you don't mind filling that out, we always want to be basing this type of stuff on what people want to know. Ed and I talked before this event, and we're actually going to start doing a series where we're going to be focusing on very specific topics. Like I said in the beginning, you probably showed up thinking that you're going to have a certain question answered, and you probably walked away maybe not having that question answered, but maybe you learned something else. We're going to try to focus in on more specific topics so that you know kind of what you're getting into. Because again, the ADA, pretty extensive, a lot of information. We just are focusing on effective communication, but there is plenty more to learn about the ADA. If you could either in the survey, if you fill it out, let us know what kind of topics you're interested in, or if you even want to put it in the chat now. You know, like I said, a lot of people said other in that poll, and I'd really be interested to know what people are wanting to learn about. Just to do a brief shout out to our interpreters. They did an amazing job. We also are just volunteer based. So all that we do and we put into the organization, all the donations that we get grants sometimes once we kind of put in the work and the time to get those grants, which has been fantastic. We're able to push back into the community, and we're either hiring deaf interpreters to do work. Right now, we're trying to recreate our website and everything that's in English. We're trying to put it in ASL right now. We are trying to hire deaf interpreters to interpret information that oftentimes is lost in the mix of this pandemic right now, specifically in the Alabama area. But events like this, you know, it does take money. We have to pay for, you know, the Zoom platform. We're paying for interpreting services. Hopefully captioning is going to work out much smoother next time. Again, I apologize. It seems like it was an error on the way we set up the event. This is a learning curve, but we want to do better next time. So if you ever think, hey, I want to donate to a nonprofit organization, we would love to take your $1, your $5. Anything really does matter. And we really do truly push that back into the community. We tried to do as much as we can to push our mission, which is, you know, promoting equity, promoting accessibility. Volunteer STEAM only runs so far. And the reality, again, is that events like this take funds to make it happen. Also, other ways to support, not financially, pushing our social media. If you ever see something that you like or that you learn that's something new, please share it with other people. Subscribe to our newsletter, stay up to date with the things that we're doing, and, you know, some of the ways that we're, you know, pushing all of those things, like what we're talking about, proactive action and reactive action. You can see what we're doing month to month. We do a monthly newsletter where we, in ASL and English, are explaining what we did that month. Sometimes it's not a ton of things because, again, we are volunteers, but we're always updating everybody because we want to be transparent. Or you can buy a really cool t-shirt, a tote, all of that stuff. You can make us your Amazon charity. Things like that all really do count, and they make a difference and make things like this possible. So yeah, again, take a moment with the survey. I think that we put all of the emails in there. And again, we really appreciate everybody's time tonight. I'm so glad you're able to join us. Thank you, Ed, again. It was so great to get more information, and this is what we needed. So you have a great night.
Thanks for including me. I appreciate it.
Yep, thank you.